May I begin, ma'am, or should we wait for more participants to join in?
It's already 4. Let's begin. And anyway, the event is live, so they'll be able to catch up.
Sure. Good afternoon, everyone. I'm pleased to welcome you all to this webinar on career in criminal litigation organized by ILSA, that is Indian Law Students Association. Our event has been graced by the presence of an eminent attorney, Mr. Vikas Pava. I welcome you, sir. My name is Vani Negi. I'm a second-year law student and the co-comparee for today's event. I begin by shedding some light on the Indian Lawyers Association, abbreviated as ILA. It is a voluntary or professional organization for the legal professionals of India. ILA aims to support the legal profession by offering access to practical resources for legal practitioners to help improve the administration of justice, establish ethical codes, and develop a professional network. More importantly, ILA offers valuable opportunities for business lawyers to network with each other and with other lawyers and professionals in related fields of practice and business. Now, Indian Law Students Association, abbreviated as ILSA, is a subset of ILA. ILSA is an independent, non-profit making organization formed with the intent to provide a united platform to law students across universities in India. ILSA plans to work in close connection and under the guidance of ILA. ILSA aims at providing its members a platform to develop their existing skills and acquire new ones, interact with fellow students and experienced practitioners from different law colleges across India, discuss career pathways, and indulge actively in community outreach programs. Although our guest speaker for the day being Mr. Vikas Pava needs no introduction, I would be narrating a brief bio of his accolades for the benefit of the participants. Mr. Pava is a senior advocate practicing in the Supreme Court of India since 1993. He has pursued cases in India as well as abroad. He has an excellent record and experience in criminal litigation and is therefore the best suited speaker to equip us all with the knowledge of what it takes to be a criminal lawyer. He specializes in cases relating to anti-corruption laws, money laundering, narcotic drugs and psychotropic substances, Foreign Exchange Management Act, serious fraud investigation of his cases, preventive detention matters, Unlawful Activities Prevention Act, and economic offenses, among others. He has argued pro bono for the association for the victim of Upar tragedy in the infamous Upar cinema case. He also argued for Shashi Tharoor in the Sunanda Pushkar case. I now welcome you, sir, and I invite Piyush to take over.
Piyush, yeah, he has joined, yes.
I'm sorry, I got disconnected due to some network issues. Should I ask question, Vani?
Yes, you can begin now with the questions.
Okay, sure. So, sir, I'm Piyush, as I'm a third-year law student at ILSA University of Law, Hyderabad. So, sir, thank you for giving a valuable time to this event. So, I just wanted to ask that with your vast expertise in criminal law, like what advice would you like to give to law students wanting to build a career in criminal litigation?
Thank you, Piyush. Thank you, Vani, and thank you, Madhura, for having me over. It's a Friday evening, so normally the lawyers who are in litigation, they keep an off on Friday evening, just to tell you everybody how they all work. So Monday, Tuesday, Wednesday, Thursdays are very, very heavy days for us. And Friday is the day when normally Supreme Court also gets free around, by lunchtime. They don't do the regular cases. And we have an advantage that even judges get tired by the weekend. So sometimes we take advantage of the fact that they are tired. So lawyers normally have a break on Friday evening. So it's a conducive day to, have a talk with all of you. As you had, suggested the topic, with regard to career in criminal litigation. So criminal litigation, of course, is a very niche field. where we as lawyers deal with the negative part of life. We deal with the crime. In civil litigation, the lawyers deal with civil disputes. But in criminal litigation, we deal with the violation of law. We deal with those incorrigible people, unscrupulous people of society who, commit crime, they violate law, and then ultimately they are prosecuted. So we deal with the negative part. So one thing which all of you should know is that if you opt for criminal litigation, then you must be ready to deal with that part of the matter. As far as I am concerned, I, of course, do this, day in and day out. This is the kind of practice I have. And I am a third generation criminal lawyer. So my grandfather was a criminal lawyer in Lahore High Court. My father is a criminal lawyer in UP in Meerut. And I am the third generation. And now my son is becoming a lawyer. I don't know whether he will opt for criminal law or not. But at least I am third generation who's doing only criminal law. So today my endeavor would be to expose you to that part of the litigation, which we all do. And so therefore, first of all, I have to say, I have to start with a heading that it is one of the most interesting professions in the world. So anybody who's choosing between litigation and the corporate world should hear me out and then take a call. And the major difference between litigation and the corporate is that normally the lawyers on the corporate side sit in their air-conditioned room. They advise clients who are basically into corporate world, and they draft documents for them, and they advise with regard to contracts and other things. Whereas the lawyers who are into litigation, their major job is to go to the court and represent their clients. And when they represent their client, of course, they have to do a lot of work right from the inception. When the dispute happens, when the crime is committed, the job of a lawyer starts. So the underlying word is the lawyer's job start post the commission of the crime. There are instances where lawyers get involved even before the commission of crime, and ultimately they land in trouble because they then are prosecuted that why you had advised someone before the crime is committed. So the lawyer's intervention is once the crime is committed, and your job is to apprise the party about their constitutional rights, about how the court of law functions, what are the laws, various laws which are important. So go to the court, represent him, and get him relief. If you are representing an accused, you have to tell him what his defenses are. If you're representing a complainant, then you have to guide him with regard to his rights as a complainant. And in case you are in defense, then of course you conduct the trial and get him discharged or acquitted. So this is a job in nutshell. I'll keep on elaborating when you ask me questions, specific questions. So our job is to go to the court, represent the client, help him in the trial, and get him acquitted. And if we are a prosecutor, then we have to prosecute and make sure that the complainant or the aggrieved party gets justice and the accused are convicted. Yes, Piyush.
Yes, sir. Sir, my next question is like, what advice you want to give to those who just like completed their law and want to join litigation, especially in terms of first generation lawyer or law student?
Okay. So to start with, let me just react to your first generation lawyer comment. There is nothing called first generation or second generation or third generation. It's a complete misnomer, right? There is nothing called nepotism in our profession, because this is a profession where everybody is answerable to the court. Although I personally feel that even being a third generation lawyer, I had to face a lot of difficulties. I had to prove myself because my biggest competition was with my own father, who was a very renowned lawyer at one point of time. Now his workload has reduced, but at one point of time when he was in active practice, he used to do 60, 70 cases a day. So nothing called first generation. So my first comment about the first generation lawyer is, don't feel that you are a first generation lawyer. Even third or fourth generation lawyer are placed in the same bracket. They may have a little bit of advantage of knowing how the system work. They know the legal terminology better than the first generation lawyer. That's all, nothing more than that. So my advice to everybody, whether you are first generation, second or third, is accept this profession willingly, right? If you want to be successful in this profession, you have to accept it willingly and you must enjoy it. So a reluctant lawyer can never be a good lawyer. So accept it. And while you are studying law, my suggestion to all of you would be to have internship at the best places. You should have internship in all the fields. During a tenure of 3 years, if you're doing after graduation, or 5 years when you're doing after your intermediate, the idea is to join as many offices as you can, have an exposure with a civil lawyer, with a constitutional lawyer, with a criminal lawyer, with a law firm, even with the NGO, and then you should take a call as to which field of law you would like to practice. Don't do it just because you like a particular lawyer. Suppose you like Vikas Pava or you like Mr. Ram Jethmalani, one of the best criminal lawyers India has ever seen. So if somebody likes Mr. Ram Jethmalani, he says, now I want to be a criminal lawyer because I like him. That is not the concept. The concept is you must have an experience in that field and then make a call. And fortunately, in this current era, when you are doing law in these private institutions and colleges and universities, you have an option of internship. During our time, we never had any option of internship. So first advice is do it willingly. Second advice is must have an internship with as many lawyers and offices as you can, and then take a call once you complete your law. The third advice is that never start from Supreme Court or High Court. If you want to be a criminal lawyer, you have to start from the grassroots level. You have to start from the district court. So district court internship should be your first internship. In fact, you can say district court can be second, because if you want to see the glamour, you have to go to the higher courts. If you want to get trained, then you have to be in the lower court. So sometimes people get bogged down when they see so many people in the district courts and they see complete chaos in the courtroom and outside the courtroom, and they see how courts are jam-packed and how multiple trials are happening in one courtroom. You get bogged down. So for training, you must go to the lower court. For practice, you can gradually come to the High Court, come to the Supreme Court, all these things. And then, of course, one thing which is very, very important for our profession is, which I would like to tell you, my first confrontation with Mr. Ram Jethmalani was in 1994, September 1994, when I came for the first time in Supreme Court. And I had a meeting with him. He was just sitting next to him as a curious, young lawyer. When I realized that he's Mr. Ram Jethmalani, I fished out a document from my, pocket, a small slip which I was scanning, and I made a request to him to write something for me. So he immediately obliged me, and then he wrote few lines for me, which I would like to share with you. He wrote that there is no substitute to hard toil and absolute integrity. If you have these two, you are on the top. Hard toil is labor, hard work, and integrity is that when you are dealing with a profession like criminal law, then your credibility has to be very strong. Your integrity has to be very strong. So it has to be absolute. Hard work and absolute integrity, two are essential ingredients. So if you are doing hard work and you are honest with your profession, nobody can stop you. You will be on the top. So these are few things which, of course, student should keep it in mind. And then how to prepare cases, etc. Obviously, you will learn subsequently. But as a student, you must know that hard work is coming. The profession is 24/7. If you like it, you don't mind doing it. We do it 24/7, even after 28 years of our practice. We don't do anything else. A day will come when you will start even dreaming about your cases, because there is so much of pressure of the cases which we do next day. Even in our dreams, we are thinking about how to argue, when to argue, how will I present my case. Particularly in the first 10 to 15 years of our career, we keep dreaming about our cases. that shows that you are dedicated to the profession. You are 100% into the profession. So if you have that kind of liking, if you have that kind of involvement in the profession, I don't think anybody can stop you from rising. So these are few tips which, as a student, you must keep it in your mind.
So my third question will be, like, you have been into active legal practice for about 30 years now. So what changing trends have you observed in a legal field, particularly in litigation?
A lot has changed in the last about 30 years. When we started our practice, when I was with him for about 2 years in 92, 93, when he used to tell me to take out a judgment, then we used to start looking at the books which we had. So I'll take out one book, see the nominal index in the end, go to a particular section, then look for a judgment. So for taking out one judgment, sometimes we used to spend 10 to 15 days. But now, in the last about 30 years, the research has become very, very quick because of the availability of technology. So today you have portals, today you have, Manu Patra, you have SCC online, and, looking into the exuberance of the youngsters and the dedication which they have. Sometimes while we are arguing a case, one of our colleagues will come out, with a judgment and say, this has been argued, now I've just found this judgment. So one drastic change or a big change which has come in the profession in 30 years is that the concept of research has undergone a change. So information is readily available. Information is quickly available to us. This is one. Second, the use of technology. We used to travel from one city to the other. Now, due to pandemic, the VC hearings have started. So today, for about half a day, I was arguing in Ranchi High Court. If I was supposed to go and physically argue, I would have taken a flight yesterday. I would have stayed in a hotel. I would have read the file in the morning. I would have reached the court, and then I would have made my submission. And then I would have come back. So today I did Supreme Court, I did Ranchi High Court, I did Rouse Avenue Court, and I did, Delhi High Court. So it has become very easy. So this has changed a lot. The infrastructure in the courtrooms have changed. If you see how the courts have imbibed into technology, how the recording of evidence has changed. When we started, we used to have typewriters, right? We used to dictate a question to the typewriter. He would type it, then the witness will answer, and the answer will also get typed. Although we have not reached a stage where in major European countries, even in UK and US, the examination is digitally recorded, where just like you and I are talking, that is digitally recorded, and in one single day 20 witnesses are examined. We have not reached that stage, but we have reached a stage where we have a computer, we can make amendments, we can take printouts. In case there are errors, then a fresh printout can be taken. From a stage where typewriter was being used 25, 30 years back, we have a computer, we have a more swift mode of recording of evidence. We have a more swift mode of writing judgments. So therefore, a lot has changed. There is no doubt about that fact. The jurisprudence has also developed in the last 30 years. So that is the positive part. There are a lot of negatives also, but today we are focusing only on the positive parts. So a great change has come from what we had seen in 90s and what we are seeing now in 2022.
So I have a follow-up question.
Yes, please.
Since we're talking about the changing dynamics of criminal law, and although we're only focusing on the positive aspects today, but I do have this query about how this phrase that we've been hearing, that jail is an exception, but bail is the rule. This has changed in current dynamics, and how it actually impacts the psyche of a lawyer, and how he defends the accused.
I think it's a very, very pertinent question, particularly in the current setup. You are asking something which we ask ourselves every day. And I'm sure, somebody must have shared this predicament with you. That's why you have come up with this question. But I have to admit that bails in our country have become very, very difficult. And even in the normal cases, cases where investigating agencies never used to even arrest anyone, you'll be surprised. We have seen times when even in a case of trap, in a Prevention of Corruption Act cases, once the trap is concluded, the trap formalities are made. Even a person is caught red-handed with money, he was never arrested. CBI, for that matter, never used to arrest these people, but they used to frame a case, file a charge sheet, then would made an endeavor to convict them rather than arresting them at the first instance. But now, invariably, every investigating agency feels that they have a massive power of arrest, and if they don't arrest, they'll be something will go wrong. So this is one thing. Second, what has changed the entire bail jurisprudence is the economic offenses. Now, economic offenses are being looked into from a different spectacle, from a different perspective altogether. So it is now being treated as a class. It has been classified into a different bucket altogether. And in all these cases, it has become very, very difficult to get bails nowadays. We have judgments which are overlapping. I remember 1978 when Justice Krishna here, wrote that famous line that bail is a rule and jail is an exception. In the same paragraph, if you read that judgment of Buddhi Kanti, Justice Krishna here said that bail is a hunch of the bench. Grant of bail is a hunch of the bench. So every judge has a hunch. Every judge has a perception. So every judge reacts differently. Now, what are the problems? Let me just address to you the core issue of why the bail law has deteriorated in the last, about say, around a decade. See, for a criminal lawyer, this is a boom time. I have to admit this fact. Not because the crime has increased, but because of so many multiple statutes which have come up. One single act committed by someone may result into multiple prosecutions. I'll give you a very small example. Small example is just an hypothetical example. A person has cheated a bank of 100 crores and has absconded and now is in UK, right? This is one hypothetical situation. So what is the first reaction? First reaction is the bank will file a case. Bank will either go to CBI or will go to EOW. So first case is registered and the investigation started. The second case is money laundering. The moment one FIR is registered, the money laundering proceedings also start, right? Third case is, if it is a company, then Serious Fraud Investigation Office will also come up and will start investigating under the Companies Act. So third case. Fourth is the investigating agency would like to extradite him to India. So Extradition Act also comes up. Fifth is if the same person has bought properties abroad and has not shown in the books of accounts in India. So Black Money Act will also come. So fifth act, right? And then in case he's declared as fugitive, then Fugitive Economic Offenders Act will also come, right? So these are just one single act will result into 5 statutes and 5 different proceedings. So lawyers have to advise their client both for the fugitive and even the bank with regard to at least 5 acts, right? And few of these acts have an embargo on bail. Take for instance, PMLA Act, right? Money Laundering Act. Section 45 says, don't release anyone on bail till you hear the arguments of the public prosecutor, and the court should come to a conclusion that he has not committed an offense. If he has not committed an offense, he will actually get acquitted. Why should he wait for the bail? He will be acquitted. So the test for grant of bail in many of these is very, very stringent. So times have changed. These acts have taken over. The transaction values have also gone up. The cheating is not in few crores anymore. It is in hundreds of thousands of crores. The magnitude has really gone up. So therefore, the concept of bail, the jurisprudence of bail has also undergone a change. So you are right when you say that there is a certain level of frustration among the defense counsels when their clients, even though they deserve bail, even though they are fulfilling all the criteria. There are few of the criteria is that there is no flight risk, they will not tamper with the evidence, they have roots in the society, they are ready to file sureties. In spite of everything available, the bails are not granted. Today, I concluded an argument in bail in Ranchi High Court in UAPA. And we are arguing this from the last about 3 to 4 days. The division bench of Ranchi High Court is hearing only bail in UAPA for the last about 3 to 4 days. So imagine when bail is taking 3 to 4 days, what will happen to the trial? So that concept of Justice Krishna here, that bail is a rule and jail is an exception, no more holds, water. And jurisprudence has undergone a change. And let us see what happens. We all lawyers, we are trying to assist the court. And there are some judges in the Supreme Court who are trying to streamline this law, who are trying to soften this law, make it more, user-friendly, make it more liberal in terms of approach. But every judge has his own hunch, and thus, various different judgments are passed every day, even with regard to the similar transactions.
Okay, sir. Sir, my other question will be, could you please shed some light on the white collar crimes under IPC? Because it is increasing day by day, especially after this pandemic.
Yes. So white collar crime, as you know, the example I just gave you probably is also linked with this question where I said that white collar crime is a crime which is committed by educated section of society, right? Where people are educated, they have the means, but they still go and commit the crime, which are normally economic crimes. It's a crime, which is either a bank fraud or a corruption matter or a money laundering case or a black money case. These are all white collar crimes. This is one field of, criminal law, which is attracting a lot of students to pick up criminal law. Let me tell you. One reason is that, of course, it is lucrative. If you are an expert in economic offenses and white collar crime, then you're dealing with those crimes. And of course, if you're good, then you command your fees from the client. And there are very few lawyers in our country who are expert in white collar crime, particularly at the top level. So it has various facets. I give you an example of one person who's gone abroad. See the kind of fields, the kind of work which a lawyer will have to do. He'll have to go and help the accused person in taking bail. Then when the investigation starts, and he has to help the accused in investigation. And when the investigation is concluded, he has to argue at the stage of charge, and then the trial, and then the judgment, and then first appeal, second appeal, and third appeal. So white collar crime is a very, very interesting field. And it deals with a very interesting facet. Like we have RBI rules, we have SEBI. It's very, very wide. I can't even confine it into 5 or 6 statutes now, because there are so many rules and regulations, guidelines, which have just come up in the last about, say, 20 years. And so you can pick up any of these fields and you can start practicing in that. So white collar crime is something which, of course, if you have a session Monday, I'll be able to tell you how, how it all works. But in nutshell, I've told you that if it's a FIR, then you have to deal with the first trial. If it is money laundering, then money laundering itself is a special statute with a special court. And it's a different ball game. There are assets, which are attached. There's a provisional attachment order, and then attachment order goes to an adjudicating authority. From there, it goes to a tribunal. So if you're an expert in money laundering, then you have few courts to take care. And money laundering also comes with a predicate offense. That's the first FIR. So it is there. And then SFIO, the Companies Act has been, amended. If you have seen the chapter with regard to serious fraud investigation office, that itself is a very niche field, right? So that is also there. And then you deal with Black Money Act, you deal with the Benami Properties Act. So these are all economic offenses and white collar crimes.
Sir, there is a question in chat box. Should I read it for you?
Yes, please.
So, sir, there's a question.
Can I directly ask if you
Yes,
don't
sure.
have any
Yeah,
issues?
sure.
Good evening, sir. Good evening, sir. My question pertains to, like, if any client comes to me with a particular grievance and asks me whether he should file an FIR at police station or should file a complaint case with magistrate. So what should I advise to him? What should be preferable and why? And also, which of the two would be more cost effective and which of the two would be more speedy in terms of justice given to him or something like that? What should I advise to him?
Yes, yes. You are Deepti Kant, right? Yes, yes, Deepti, I'll just
Yes,
answer
sir.
that. You know, FIR and complaint, these are two different things. So yourself, your question itself contain FIR is the first information report which is registered with the police, where the complainant's job is only to, just address a grievance in a form of a complaint. If the complaint discloses cognizable offense, the police will register the FIR and start the investigation. Now, admittedly, police have much wider power when they are investigating an offense. They have a power of arrest, they have a power of search, they have a power of seizure. They can go and collect the material from anywhere they want. They can take the help of a forensic expert in case there is a complicated evidence which is involved. They have a right to go to the hospital, take a help of a doctor, so on and so forth. So they have much wider power of investigation. They have a power of summoning anyone. For instance, they want to collect evidence. They can just write a letter under 160 CRPC or under 91 CRPC and tell a person to bring documents. But when you deal with private complaint, then it is the complainant who's prosecuting. Complainant doesn't have all these powers. So complainant has to request the court to do it. So first answer to your question is, seeking FIR and getting the matter investigated is a more easier option. It's a more speedy option. And once you take help of an independent agency like police, then of course your job is reduced to only pursuing the matter, and then you hand over the job to the police, which is an independent investigating agency. Now the risk is that nowadays you don't trust these officers for an independent investigation. You know how in our country the reputation of the police is. It is not one of those Eastern European countries where the police machinery is so efficient that you can't even doubt about their credibility and honesty. So then you don't mind approaching them and giving them the opportunity. There the laws are also different. There they have a power of recording confession which is admissible in evidence, knowing that police will not wrongly register any confession. But in India, you can't trust these cops. So it is cost effective. It saves time. You go to an agency which has an authority to do very wider aspect of investigation and then file charge sheet in the court. And when you go and file a complaint, then of course it takes its own time. Once you file a complaint and it gets adjourned, then you may get a second date after, say, about few months. So in a span of 1 year, you may get 3 or 4 dates. So the progress in the complaint is very, very slow. But yes, there are certain cases where you don't trust the police and you register your own complaint. Those are cases where the complaints are filed. So it depends on the offense. It depends on the circumstances. It depends on the nature of the parties to decide which one is better. Both have their own pros and cons.
Sir, in case a person comes to me and he's very poor and says that police is not registering his FIR and asking to wait for a day or 2 or 3 days, then in that case, should I ask him to go and file a complaint, or what else I should advise him?
In that case, you can go to the court, file a complaint with a prayer under 156(3) of the Code of Criminal Procedure. 156(3) is the power of the magistrate, where the magistrate can direct the police to register the FIR in case they are not registering. So they will ask for an action taken report from the police and ask them what action have you taken on the complaint which is already filed. If they are not in a position to satisfy the magistrate, then magistrate has a right and the power to direct the police to register. So rather than filing a private complaint, they should the aggrieved party must file a complaint under 156(3) and seek a direction from the court for registration of FIR.
Okay, so sir, there is another question in chat box. So can you please also provide some insights for cyber law related crimes? Do lawyers get to deal with cyber law or forensics generally while litigating a case or criminal offense nature?
Yes, very often, yeah. Now, nowadays, particularly in pandemic, you see, when pandemic started, people were at home. Most of the time was stuck at home. At that point of time, the cyber crime was on a rise, where all these people who hack your computer, who make calls to you and then send you a pin and tell you, because everybody now is buying stuff online. So you have the provision of making payments online. So a lot of cases came up where, these accused person will make a call to someone, will share a pin and then take out money from their banks. So I have dealt with few of those cases. So of course, we have Information Technology Act of 2000, which deals with these kind of crimes. Plus the Indian Penal Code also deals with it. So we have a lot of crime. There's a series of offenses with regard to obscenity on internet, which comes up, cheating, which comes up, forgery, which comes up, and then theft of source code, theft of various things online. All these cases are come up. That is also a very niche field. Cyber law is also very, very interesting. Cyber law does not deal only with the offenses. Cyber law also comes when we are dealing with a normal offense. For instance, how to prove a document, electronic document in a court of law is a part of cyber law. Section 65B of the Indian Evidence Act talks about how an electronic document has to be proved. When you get a document from a bank, for instance, say a statement of account, and you produce it in a court, then the court will have to presume the authenticity of that document if you accompany the statement with the Section 65B certificate. So these are all issues which are arising from cyber law. So cyber law is very, very interesting. It's a niche field. One has to master Information Technology Act and also the amendment which this act brought in IPC, in CRPC, and also in the Indian Evidence Act. Cyber defamation is something, which is again very interesting. Now, in this, era of social media where you have Instagram, you have Twitter, where people come and abuse, they start trolling you. So these trolling and abuses also are punishable. If somebody wants to take a person who has trolled him or abused him or threatened him to a court of law, that is called cyber defamation. So cyber defamation also have to be separately dealt with. And if somebody wants to prosecute an accused for defamation, there he has to file a complaint. Like Deepthi has asked a question about FIR and complaint. Defamation cannot be investigated by police. Defamation is against an individual. So individual has to prosecute. So section 199 CRPC and 499 and 500 of Indian Penal Code are two very important sections. 199 of CRPC, not IPC. If you read both, you will understand what I'm saying.
Sure, sir. One question that I wanted to ask, that you have appeared pro bono in association of Upahar tragedy case, infamous Upahar cinema case, and also you have appeared, you argued in Sasi Tharoor case, like in Sunanda Pushkar death case. So how was your experience in those cases? Could you please share your experience in those cases?
Upahar tragedy happened in 1997 when I was with Mr. Tulsi. I was his junior. I had just joined the profession and this tragedy happened, and a very unfortunate tragedy where 59 people died. So we were approached by the victims in that case. And I remember when we had a preliminary meeting with the victims, first thing which Mr. Tulsi advised them is that if you have to fight these huge, rich and powerful builder lobby, then you have to join hands. You can't fight in your individual capacity. You can only fight when you form an association. So we drafted, the rules for them, and we formed an association. We got the association registered, and we started advising them. This was 1997. Imagine now we are in 2022. So from 1997 till 2022, there are many cases. There are some offshoots which have come up. We represented them from the lower court till the Supreme Court without charging even a single penny. Our dedication to this case is to such a level that if I have to choose between Upahar case and a case where I may be getting the highest ever fee, I will choose Upahar. I will not go to any other case. That is the kind of dedication and involvement we have in that matter. So we had filed a civil case for compensation for the victim, which we filed in Supreme Court. Supreme Court referred it to High Court. High Court, battery of lawyers came and opposed it. We won on maintainability, which again went to Supreme Court. And then again in the High Court, it started. Ultimately, we got compensation for all the victims, which was challenged in Supreme Court, upheld in Supreme Court. See, imagine there are so many accused persons. There were hundreds of lawyers on the other side, but we, right from 1997 till date, we stuck to our job and we gave our 100%, and ultimately victims are compensated. Same thing happened with the criminal trial, where Ansal brothers and the others were accused. The trial was concluded, and then appeals were filed in the High Court and Supreme Court. We did throughout from the trial court level. And now there's a case of tampering. They tampered with the trial court record in main Upar case, so they are being prosecuted. In the main case, they were sentenced for 2 years. In this case, in tampering case, they have been sentenced for 7 years. And at present, they are in custody. They are suffering the sentence. So we are quite happy. We are quite proud of our hard work, right from Mr. Tulsi and all our colleagues who have given so much of time and energy to this case. And it gives a level of satisfaction. It's a very different level of satisfaction to represent victims who are helpless, to represent victims who don't even know what is going on in the court. Most of them are not even aware what is happening in the court, except two people who are spearheading this entire process, Mr. and Mrs. Krishnamurthy. So it's a great level of satisfaction. So my one advice to all of you would be, in your career, whenever you get an opportunity, you must pick up these kind of cases where the victims don't get proper representation. So it's kind of a legal aid which you provide to the society. Second, of course, is Dr. Tharoor's case. Dr. Tharoor's case, of course, a very, very unfortunate case where his wife died, and it resulted into registration of a case, which of course was absolutely bogus. But somehow the case was registered and then investigated and charge sheet filed. And right from the beginning, I was very, very confident that this is a perfect case where he should get discharged. Of course, he used to get multiple opinions from various corners that challenge it in the High Court, challenge it in the Supreme Court. But what advice and what one lesson which I have learned, and also I would like to share it with everyone, is that it's not necessary that in every case we have to go to the higher courts. Sometimes we have to trust the district courts. District courts are more powerful in terms of granting relief on the criminal side. And in this case, of course, fortunately, we were before a brilliant judge who gave us time and who gave us the opportunity to explain the case in so much of detail, and gave me the opportunity, to demolish the entire charge sheet in the court, which resulted into discharge. And of course, he was extremely overwhelmed when this order was passed. And this is a great learning process, that even in such a heinous charge, I'm not saying offense, in such a heinous charge, somebody can be discharged even at the grassroots level. So both these experiences of mine are, once in lifetime experience. And I learned a lot, and I would really treasure, these two cases. They are very close to my heart.
Thank you so much, sir, for that conclusive answer. I do have a follow-up question.
Yes, ma'am.
In certain high-profile cases, such as this one that you just mentioned, there's a phrase that actually came to light after the Sushant Singh case, that is media trial. So in case of a media trial where the case actually comes into the limelight, what pressure does an advocate pursuing that case goes through, and does that have say a substantial impact on the case itself, on the merits of the case?
Yes, I think again a very interesting question, and it's a fact that if a very high profile person is involved in a case, then it catches a lot of attention. The media picks up, social media picks up, and it becomes a media trial. So what is a media trial? Let me explain it to you. I have no objection if the court proceedings are discussed in media, right? Something which has happened in the court, like you have live law and bar and bench who are perpetually reporting the court proceedings. I have absolutely no difficulty in that. The difficulty arises when the investigation of a particular case, the evidence of a particular case is discussed by a group of people sitting on a television channel who have absolutely no knowledge about the Indian Evidence Act, who have no knowledge about what investigation is going on. They start making judgments. They start evaluating the evidentiary value of that circumstance. They thrash out the entire evidence and then they pass judgment. A person is, guilty or is innocent. I have a serious problem with this issue. That is why in this case, fortunately, when this entire thing started, the first advice which I gave to my client is, please don't speak to media at all. No matter what they say, no matter what they do, of course, it's defamatory in nature. But my advice was, don't respond. And fortunately for us, he never responded. He never ever spoke in a span of 7 years, never gave any opportunity to anyone, to make any attempt or to involve him into some kind of a dialogue or a discussion. Because we always took a stand that the matter is sub judice, so therefore court is dealing with it. There were certain channels, of course, who took it to the next level. We filed cases against them. We tried to seek injunction against them. The suits were filed in the court. Even FIR was filed to an extent that some material, which was a confidential material, which was only with investigating agency, was shown on a television channel. We filed a case of hacking and theft in that case. That is also pending. So as far as we are concerned, in this particular case, I tried my level best to make sure that somehow we stall that. But if the person concerned is so high profile that every person who wants to associate his name with the person would file some kind of a false case or a fake case just to get popularity. So if you file a fake case against a very influential person, your name will appear in the newspaper, so you get publicity. So a lot of them used to do it only for publicity. But fortunately for us, the courts came to our rescue, and as far as I am concerned, in the criminal matter, I took an injunction that the court file should not be given to anyone, should not be shared with anyone. And the court passed that order. Till date, the investigation file or the court file was not even given to media, which was so good, because I said that it affects my fair trial. It affects my reputation. So therefore, the court came to our rescue and passed that order. That order was affirmed. Still, a lot of people made efforts, and some out of context statements were made, and just to gain publicity. So of course, media trial, even in Sushant Rajput case, just imagine, for a few months, our entire country was involved in that matter, right? Every individual, say about 100 crore people of our country, were glued to the television and were watching only this. They were not watching anything else. They were not bothered about what's happening in the country, what is the economic condition, what is the law and order situation. They were only concerned with Sushant. And once the purpose is achieved, nobody is talking about Sushant. Where is Sushant now? So, this was also for a purpose. But at the end of the day, that hashtag justice for Sushant, where is that? Where is investigation? Where is charge sheet? Where are the accused persons? So therefore, times have come where these television channels have lost their credibility. People are not interested in watching what's happening there. I don't watch news anymore. It's been now almost 2.5 years. I prefer to read newspapers in the morning. So, newspaper is, of course, we read more of editorial. News is a fact which is shared with you. But what is nowadays shared with you is an opinion, not a news. A fact is shared with you, which is also saddled with an opinion of the writer. So they are just trying to tell you that this is what we feel. So therefore, there's no point, reading that material. So trial by media is something which, of course, our country should take it very, very seriously. We should have a legislation to stop trial by media, particularly in criminal cases. It does great injustice both to complainant as well as to the accused. It's not good for society at all. But unfortunately, it is allowed, and only in exceptional cases some orders are passed where some relief is given to the parties concerned. So therefore, that is true. Yeah, I think what the question you have raised is the apprehension, and I've said that it is not good for criminal justice system at all.
Shreyam, you wanted to ask a question, you can go ahead.
Yes, am I audible?
Yes, please.
Yeah, good evening, sir. I'm Shreyam from second year student from ILSA. My question is with regards to the increasing use of legislations like UAPA and the preventive detention legislations in NSA. What role do lawyers play? And you have your foot on ground every day in criminal law arena. What role do lawyers play in protecting the so-called principles of justice, equity, and good conscience, which we have been reading all through this semester? What role do lawyers play in preserving these three pillars in favor of the citizens in light of the increasing use of these legislations? And also, how deep are the tentacles of states, personal interests into these cases? How deep are these cases influenced by the interests of the state?
You're right. There is a great misuse of few of these statutes in our country. UAPA is one of them. And prior to that, it was POTA, and then it was TADA, all those cases, where terrorist activity was defined and is being prosecuted. So ultimately, now it is UAPA where a chapter was included as to what is terrorist activity, how it is punished, how terror funding is now an abetment conspiracy of a terror attack. So all this is there, and of course, there is no doubt about that fact that these statutes are made, they're constituted for a particular class of people. Now you have writers, you have authors, you have journalists who are being prosecuted. Today we argued for an industrialist. Imagine industrialist who's giving employment to 5,000 people, who's paying GST of 500 crores, is also being prosecuted. Of course, maybe for some vested reasons. As you say that these statutes are so stringent that the moment you apply these statutes, even in a case which does not deserve its application, a person goes in for about 6 months. So there is no doubt about that fact that they are misused, but then we have courts of law who should take care of the misuse and should intervene at the right time. And we as members of the bar, particularly on the criminal side, who expertise on criminal law, we try our level best to make sure that we fight and we assist the court to such an extent that we expose the false implication. We assist the court in development of law so that judgments are passed which are helpful to the citizens of the country. But one judgment, suppose UAPA case reaches a particular bench and the bench feels no, it's a very serious matter, and then lays down the law. So one judgment can have an impact, particularly if it is from Supreme Court, across the board all over the country. So then the second judgment takes its own time. So in UAPA, there is a judgment of Zahur Watali of division bench, which was passed about 3-4 years back. Now a new judgment in KB Najib has come now after 4 years. So for 4 years, the prosecution department is citing Watali and making sure that people don't get bail by saying that the bail laws are very, very stringent. You have to come up with an opinion, give a finding that no offense is made out. So all this is there, but as a lawyer, as I told you, we have to be more open-minded. We have to help in the development of bail jurisprudence to the court, and then ultimately the court rectifies and then passes a better order. So UAPA is one, and ED PMLA is another, which is again quite grossly misused nowadays. But if you talk to a prosecutor, he will say it is not being misused. If you talk to a defense lawyer, he will say it is being misused. It depends on which side of the law you are. But fact of the matter is that as a counsel, whether you are a prosecutor or a defense, your job is to assist the court. Your job is not to get aligned with the state. Your job is not to get aligned with the accused also. So we have to be independent. We have to make sure that the rule of law prevails. We have to make sure that the constitutional provisions are protected. Article 21 is protected. The procedure for trial, should be fair and should not be unreasonable. And so all that. So our job is to make sure that we assist the court in the right perspective.
Ajuni, you wanted to ask a question.
Good evening, sir. And it has been a lovely session till now. I thank you for that. My question to you is that with time, and especially now, there has been a lot of streamlining of careers. So people are either choosing, like earlier, there used to be a broad spectrum of either civil or criminal, but now there are several more facets of law that are being exposed to us. And sooner than later, people are choosing to streamline their career rights at the beginning of their career. So because this talk is about criminal law litigation, so what would you say to students who aspire to practice criminal law, that whether they should be streamlining their careers right at the beginning, or should they have an exposure to everything right at the start?
Okay. No, I'm very, very clear on this, Arjuni, that as far as student of law is concerned, you have to expose yourself to all the fields. So when you are studying law, then you must have internship in almost all the fields. But when you start practicing, then in the first 2 years, like I always say that if you want to practice on the criminal side, you must spend at least 1 year on the civil side also, because there are overlapping. Now this breach of contract may result into a civil remedy as well as the criminal remedy. So therefore, for an authentic criminal lawyer, 1 year of civil litigation is mandatory, according to me. It is very, very necessary. One should do it. But if you want to plan your career, one should plan the career in the 5th year of law, or maybe in the 1st year of, your profession. But before that, you must have an experience with all the field, because I don't want a person should, come up after 5 years and say, sorry, I'm in a wrong field. I've chosen a wrong track. I should have been a lawyer in the insolvency case, in the insolvency field, or a civil field, or a banking field. So once you start, you don't get a U-turn, because when you spend 5 years, say in a particular field, then taking a U-turn is very, very risky. And then it takes another 5 years to get acclimatized to the new field. So while studying law, try everything. But while pursuing law, you can start with civil, then go to criminal, or you can start with civil. If you start liking civil, you can continue with civil. But it is important that you choose your career quite early in your profession. One should not change after a few years, because your gestation period in almost all the fields of law is very, very long. You take 5 years, 6 years, 7 years time to get acclimatized and to get adjusted in a particular field of law. So it's better you choose it at a very, very early stage, but there is no, time limit as such. There is no straitjacket formula that you have to do it in the 1st year, 2nd or 3rd year. First few years, of course, are tentative. So one should be open to anything. But if you expose yourself to a particular field in the right perspective, say you join a right chamber on the criminal side and you get attracted, and of course you will pick up criminal law. Same is with civil law also. If you join a good civil lawyer who shows you the real path, who shows you the real field of civil law, you may get attracted to civil law also. So one should not be stubborn. One should not be inflexible enough that you don't change. But in the first 2 to 3 years, one should choose what exactly he wants to practice in. If it's criminal, it has to be criminal. If it's civil, it has to be civil. That's my view.
Thank you, sir. That answers my question.
Yes, yes.
So there's one question in chat box that in a case like if someone wants his case strong and wants to collect an evidence, and due to lack of evidence, the plaintiff or prosecutor try to hack Gmail or social media ID of defendant or counsel, or vice versa. So if those evidence proves the guilt of the accused, but the evidence obviously, of course, collected was not legitimate. So, sir, what is the solution for that?
No, the question is that the method of collecting evidence is not legitimate.
Yes, sir.
What will be the evidentiary value of the evidence? This is the question.
Yes, sir.
Well, the law is very, very clear on this. We have the landmark judgment of Puranmal, which says that if, which actually deals with the income tax rate, and which has held that if the tax rate is not in accordance with law, if the tax rate is not legal, then whether the material which is collected by the income tax department can be used against the assessee or not, and the Supreme Court said yes. But at the same time, like what I argued few days back is with regard to interception of phone. Now, interception of a telephone is an invasion of right to privacy, which is now a constitutional right under Article 21. So the CBI was arguing, my argument was that the interception is not in accordance with law, and the order which is passed under Indian Telegraph Act is ultra virus to the act and to the rules. So therefore it should be quashed. So once the order is quashed, what will happen to the telephonic conversations which have been recorded? Right? So my job is that if the foundation, if the initial action of the government is illegal, then, and the foundation is illegal, then the entire building will collapse. But it all depends on the facts and circumstances. In income tax department, they say, yes, if it is illegally procured, then it can be used. But I have argued yesterday that if the order goes, then the telephonic conversations also go. So in your case, in your question, you are saying the material collected with regard to hacking of a computer is not legitimate. Then whether that information can be used or not. So the law is very clear. Unlike in US, of course, it is completely prohibited that if the means are not good, then the result, of course, will not be good also. But out here, it all depends. If I am for a defense, I will say it can't be used. If I am for a complainant, then I will say, then how would you overlook the overwhelming evidence which has just come up against the accused, and you can't ignore it. So it depends on facts and circumstances how we use it. And there are, at the moment, if there is a constitutional violation, in my case, I'm saying right to privacy is violated. So therefore, it is bad in law, and therefore the evidence is unreliable. But if there is no constitutional violation, then I think it can be used. The evidence can be used in the court of law.
Sir, I have a question.
Yes.
Sir, as you said about legal aid, I, as an advocate, wants to oppose a bail application in a case where I think the accused is the real culprit. Although I am not related to the victim in any way, still, just for the sake of justice, I want that person to stay inside the prison. Then can I oppose that bail? And if so, then what is the procedure of opposing the bail application? And at what stage I can become a party in the case to oppose the bail application? Just to make sure that the person stays inside.
Look, in criminal law, there is something called locus standi. In criminal law, it's only the parties who are related with the crime are permitted to participate in the proceedings. Right? It is not a public interest litigation. In PIL, anybody can come and raise an issue, file a PIL in the interest of public at large. But when we talk about commission of an offense, when we talk about criminal trial, we talk about investigation, then only related parties can come in. I'll give you a small example. In Dr. Tharoor's case, the anticipatory bail was granted by the court. And then a lawyer from the bar, he filed a petition in the High Court saying that how bail is granted to this person in an offense of 306. And of course, I stood up in the court and said that it's a publicity petition, where of course a lawyer wants to get his name involved in a case so that he gets publicity. But coming back to your question, he had no locus standi to come to the court and challenge that order. There are many judgments of the Honorable Supreme Court which says that unless and until you have a locus, unless and until you are involved, either you are an informant, or you are an aggrieved party, or you are a complainant, only then you will be able to participate and oppose any petition. So I don't think an individual citizen can do it, but yes, if the lawyer is in a legal aid and the complainant does not afford any lawyer, then he can approach the legal aid and legal aid will provide a counsel. So legal aid is
Sir,
given only when it is requested by someone.
sir, in case victim wants to oppose that bail application, because generally because bail application is filed against the state. So if victim wants to oppose that bail application, then at what stage it can become a party to that?
Yes, of course.
That
Victims appear every day in the court and they oppose. The investigating officer is duty bound to inform the informant that the bail application has been filed. When bail application is filed, the
is there
informant.
any IA or
Sorry. Yes, there are
is
many
there any
judgments.
kind of application or something that
No,
needs to be filed on the
for,
side of victim?
for bails, applications are not required if the complainant or complainant's counsel reach the court and start opposing the bail. I don't think any judge in our country will object to that. They always encourage. Although it's a state case, all the prosecutions are done by the state. If you go technically, then the accused counsel can always raise an objection that it's a state case. The complainant can only come and assist the prosecution. If you read section 301, 302, the complainants have very limited role. But principally in our country, I don't think any judge stops or refrains the complainant to come and argue in the court. And even the defense doesn't object. So you don't need to file any application. Just go to the court when the matter is heard and say that I'm appearing for the complainant and start arguing. Of course, after taking permission from the prosecutor and the court.
Okay, since we are running short of time, I want to ask one last question from sir. Sir, how was your experience arguing cases in foreign countries like UAE and Greece? Could you please say something about that?
Well, UAE, I basically didn't argue. I was only assisting a Queen's Counsel from London because in UAE we have Dubai International Financial Center, DIFC, which has a court of its own and where the common law applies. So there they have judges from common law countries. So there are, judges from the Chief Justice from Singapore, and then there's a judge from Australia, UK. So the Queen's Counsels who are registered in UK are permitted to come and argue. So very often in a contested matter. So this was a contested matter where I was also engaged from India and I went. But I had very limited opportunity to argue, but it was a good experience. Now, what was good is, which I can share it with you, is when we appeared in this court and there was a judge, a British judge, who was hearing us. So while we were arguing, in front of us on the dais was only judge. There was no secretarial staff. So we're quite, surprised to see how a judge controls the entire court. There is no one who's supporting him. Unlike in India, where every judge is surrounded by half a dozen people. You have court masters, you have readers, you have peons, and you have court clerks, judicial clerks, 6 or 7 of them assisting, but he was alone. So later on, when I inquired, I found that the entire proceeding which we conducted was not even video recorded, but also digitally recorded throughout. Everything was recorded. It was video, it was audio, and by the time we came back in the evening to our hotel, we also got the recording. And behind the curtain, there was a person who was also taking the dictation, and the dictation was also video recorded. And I think within the next 24 hours, a transcript was also prepared of the order, which was shared. So he heard us, he dictated the order in open court while he's alone, digitally recorded, transcript prepared and shared with the parties. So what a great experience. You don't need so many people. If you have technology to your advantage, then everything can be recorded. Unlike in India, where we make arguments before the court, sometimes we give written submissions in the court, but they are not reflected in the order. But if the entire proceeding is digitally recorded and you have made a submission, then in the appellate court, the lawyer can always say that, look, I made this argument, but the judge has not dealt with this argument. So use of technology was, something which really inspired me on that day. And this was around 5-7 years back. Now going to Greece was also, a great experience. In that case, my, senior was a local counsel. He was Greek counsel, aged about 80 to 83 years of age. And meeting him, interacting with him again was a great experience. He was a stalwart of that area. And it was in Greek, so of course we could not have argued, but we prepared everything. We prepared cross-examination, we prepared the arguments, we gave them the strategy, and all our arguments, all our documents were translated into Greek and then given. And we had an interpreter who was from America who used to tell us, and then we used to tell the lawyers to ask questions. Again, what really inspired me there was the use of technology. How in a span of couple of years, we won the case in the trial court, then we won the case in the High Court, and then we won the case in the Supreme Court in a short period of, I think, 3.5 years. And the use of technology was, something which I must share with you. The trial court there is a court which deals with the felony offenses primarily. So if it's a felony offense which is punishable for 5 years, you have 3 sets of judges. So 3 sets of judges means the trial will be conducted before them and they will have a majority verdict. Unlike in India, even 302 case, which is punishable up to death, the trial is conducted by one person. So one person can commit an error, but 3 people will not commit an error because at least there is a majority. Either 2:1 or maybe all 3 may have a unanimous verdict. So their criminal justice system, the hierarchy is like a pyramid. They have very, very strong base. They give too much of importance to the trial court judges, and trial court judges are respected. And if trial court gives a unanimous verdict of all 3 agreeing together, then there is no appeal. Then the appeal is only on the question of law, just like we have Article 136 in the Supreme Court. So see, their hierarchy is like a pyramid. We start with 1 judge, then we go to a 2 judge, and then we go to Supreme Court. So that is one distinction which I noticed, and I realized that even if in our country, if the trials, at least of murder cases and cases like UAPA or any other heinous offense, be tried by at least 3 judges, then the justice will get affected. So, and then technology, coming up to technology, the courts over there invited all the witnesses in one go. So 20 witnesses are invited in the morning. They are called, they are summoned, and they are given mic. So everyone has a mic. So when we cross-examine a witness, we ask question, the witness answers, we ask question, the witness answers. Within say about half an hour, the testimony is over. Again, it is digitally recorded and transcript is prepared subsequently. Unlike in our country where we ask a question, it is recorded on a computer, then the witness answers, again it is recorded. So one witness sometimes takes at least 7 to 8 dates. 7 to 8 dates means 6 to 7 months. So use of technology in that part of the world expedites the entire process of trial, which was a great experience. And one thing which I would like to share with you about that lawyer, who was one of the top lawyers of that country. I asked him, he was also a criminal lawyer. So I asked him, sir, what do you, what can you share with me as to what is the secret of, being such a great criminal lawyer in Greece? So apart from general hard work, etc., one thing which he shared with me is that a good criminal lawyer has to be a good dreamer also. He says a lot of my strategies are found when I am dreaming and I'm sleeping, I'm just thinking about it, lazing around, and I am, deciding about my strategy. That means the facts of the case are in his mind, he's thinking about it, and he's thinking about how the crime must have happened, and then he would come up with a strategy. So it's not that you read a book, read a file, and then come up with a strategy. You have to go back, start thinking about it. You may come up with, a great defense. So therefore, both these places, I had a great experience, and exposure in foreign country, plays a lot of role in your life, then you start comparing and you start working towards, improvising your own criminal justice system. So I tried, I came back, I saw, there, how do they function, what kind of office management they have, how do the law firms function, and then we want to bring those changes here. It makes a lot of difference. So if you are in litigation, of course, you get an opportunity to travel all over the country and world. So I can say that I had a great experience. And I wish that all of you get an opportunity at least once or twice in your life to go and do cases abroad. It'll be a great thing.
Okay, thank you so much, sir, for your valuable time. And I'm sorry for all those whose questions couldn't be entertained. We are already running short of time. So, yeah, Vani, please.
It has indeed been an enriching session. First and foremost, I thank Vikas sir for the conclusive answers and explanations through which sir emanated crucial know-how pertaining to today's topic of discussion. And again, I thank him for taking out his valuable time and agreeing to be a part of this session on a Friday evening. I'm sure most of the participants, including myself, with a bent towards criminal law, have greatly benefited from the practical nuances and inputs highlighted by our guest speaker. I thank all the participants for being attentive and cooperative throughout the session. Last but not the least, I thank ILA, ILSA, specifically Madhura ma'am, who is the executive director of ILA, and my co-compare Piyush for ensuring the smooth conduction of this event. In case anyone from the participants wishes to join ILSA, all the registered participants would be mailed an automated form. You can fill it and subsequently you would be contacted by the ILSA. With this, we now conclude the session.